But very quickly, if I may, the point about unchallenged medical evidence and proceeding in the face of unchallenged medical evidence, and I say that my client's doctor's evidence, when properly understood, is unchallenged. That point is made by the same authorities relied on by our learned friends. So, for example, at paragraph 16 of the Hyatt case, which can be found at pages 6 and 7 of their authority bundles, that point is made. That point is also made again later on in that paragraph, in that judgment, at paragraph 32b on page 12. And interestingly, it says, it would be wrong for a committee which has the livelihood and reputation of a professional individual in the palms of its hands to go with a hearing where there is unchallenged medical evidence that the individual is simply not able, and I'm using the word able to not use the word in the quotation, to withstand the rigors of the disciplinary process. And why I emphasize that is because the position taken by my client is that the secondary evidence, the CCTV footage, the geolocation data, even their own doctor's report, doesn't challenge the medical evidence properly in the way that the medical evidence is in front of you.
I'm not sure that that's a good point because I think at the last appearance, you strongly oppose any idea of an assessment by an independent doctor. So on that basis, there can be no question of us having a report by a doctor challenging what Mr. Carrim's doctor says. So we all understand why there is no opposition.
No,
it's not as if with an opportunity available for another doctor to counter this doctor's report, no counter was furnished. It's on that basis that I feel that's not a strong point at all.
I respectfully disagree with you, Chair, in the following two respects. On the last occasion, it was not that I had any objection to an independent exam being performed. It was whether or not it could be compelled and whether or not any inference could be drawn.
That boils down basically to the same thing, because in expressing your view that compulsion was not possible, the upshot of that was that you were opposing. That was opposition. And you even, that was the context in which you referred to the rule in the context of civil proceedings. You said, you questioned our power.
Correct.
Our legal power to even compel.
Correct.
That's opposition. So
yes,
I don't understand.
But then you and I landed on the agreement that no adverse inference could be drawn if it's a voluntary process.
That's something else.
No, but that's the point I'm making. The point I'm making is opposition, so to speak, at that time, in the way in which we understood the Commission's case, was on the issue of the compelled examination. What I'm saying in response to this issue as a continuation of what just happened between yourself, Chair Commissioner Baloy, and myself as well, is that if the voluntary examination is the mechanism, with the interposition of Mr. Carrim's own doctor or not, then that would be fine, because that also means that no adverse inference can be drawn if he declines to not participate in that. That's where we landed last time.
No, you never. I accept that today you have made the point that in principle there is no objection to this happening, but that's subject to instructions being, or rather you're instructing attorney, finding out what the position will be in terms of an acceptance or otherwise of the assessment. You are saying something like that for the first time now. On the previous occasion, you strongly argued against it, making the point that we simply do not have the power. And you distinguish the fact that we do not have the power by making reference to the power that a high court has in civil proceedings in terms of the rules. At no stage did you ever get to a point that said No, 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 no. We are amenable to we are voluntarily amenable to an assessment by another doctor. You never got to that point.
Because the debate didn't get that far, with due respect. Where we ended, and we were having a general conversation, is that I ultimately accepted that if it were a voluntary process and that no adverse inference could be drawn as to the participation in that voluntary process,
but
that's where we left it.
But Mr. Premier, did you, because more than one letter, in fact, at least two that I remember from reading these papers for this postponement application, more than one letter was written to Mr. Carrim's attorneys requesting him to avail himself for an assessment by an independent doctor. Initially, there was no response. And was there a response the second time around? I'm not sure. But here, in open session in this commission, what we got was the vehement argument by you against that as a possibility. That's all that we know. So for you to suggest that, however, there could have been the possibility of a voluntarily agreed to assessment comes as a complete surprise to me, because the attitude throughout, especially in the face of the two letters that were specifically asking for this assessment, what you say now simply does not accord with that history. That history culminating in your argument before us here. If Mr. Carrim was prepared at all to subject himself to the assessment, we should by now have received something from him or his attorneys saying that here I am willing to subject myself to that assessment that the Commission's attorneys have asked for more than once. So I don't understand your argument. Insofar as it relates to the possibility of Mr. Carrim subjecting himself to the assessment voluntarily, I do not understand that part of your, not in the face of the history I'm referring to.
No, I accept that, and I'm not going to try and relitigate that history now. I think I'm going to go and read the transcript, because at this stage, I'm going to respectfully say recollections may vary, and then I can come back to you and reply and clarify that as needed, because as I say, I remember the debate having happened slightly differently, and it was on the characterization issue about voluntary or compelled, and it didn't go beyond specifics about what if it's voluntary, then what is the instruction, in the way that it was put to me today. And in light of the new evidence that has come about less intrusive means, that's why I gave an in-principle answer subject to my instructions. But I'll read the transcript and I will come back, and if I'm wrong about that, then obviously I will be wrong and I will apologize to the Commission accordingly. But if I can move on.
Just to protect myself from a full-on egg on my face, let me say I'm also only human and fallible, so my memory may also be inaccurate. Please continue.
Yeah, well, that's why they have appeal courts. They can correct the lower court judge's memory. But no, Judge, thank you. I accept that. Let me just say this. The other mechanism available is that there could have been, in terms of direct challenge to Mr. Carrim's doctor's evidence, is that instead of the report that was put up, which talks about a subsequent process, which is I'm going to describe as collateral, a rebuttal witness could have been brought. And the rebuttal witness, like ordinarily happens in civil litigation where there are contesting expert witnesses, which doesn't necessarily involve an inspection in loco per se of the incident or the person, is possible, and that wasn't done either. You've already heard me. I was going to take you through the authorities, but I don't think that that's necessary for me to do so, except to refer to one judgment, if I may, which is one that's cited, I think, by both of us. It's a South African judgment. It's Michael versus Linksfield Park, 2001, Volume 3, SA 1188, SCA, at paragraph 39 in particular, I just gently point out that there the SCA said, the assessment of medical risks and benefits is a matter of clinical judgment which the court would not normally be able to make without expert evidence. And so that's the point that I'm making. Insofar as there's direct medical expert evidence in front of you is concerned, there is no rebuttal of that. It remains unchallenged, and the Commission should be slow to draw any inferences from alternative sources of evidence as to what clinical value it has or it doesn't have. Because that alternative evidence is not clinical evidence, and with all due respect, you don't have a duly qualified clinician in front of you who offers an alternative view about Mr. Carrim's clinician's view of Mr. Carrim. In fact, the expert report put up by the Commission itself expressly qualifies itself by saying, I don't offer an opinion on the underlying medical assessment made by that clinician. So, insofar as the clash of evidence and the weight to be attached to the evidence is concerned, in the exercise of your discretion as to whether a postponement should be granted, I come back to the point that the stronger evidence is Mr. Carrim's clinician's direct evidence and not all these alternative sources of evidence that the Commission may rely upon. You've already heard me on the issue of the electronic data cannot answer the medical question. I've made that point a few times. I don't think I'm going to go there unless the Commission wants me to. You've got that in front of you. All I would say, and having read the papers this morning again, as well as the correspondence, you also know that there's I'm going to use the word challenge, but I'm going to say it's inverted commas. There's a challenge to some of the evidence in front of you, how it was obtained, but more than just simply how it was obtained, whether it's reliable because of identified instances of errors in that evidence. I don't think that you necessarily have to make a ruling or determination on that today. It's simply to say that in the assessment of the evidence is concerned, you've got questions about at least reliability, and to the extent then any weight is going to be placed on that, you should place less weight on that than you should the direct medical evidence in front of you. Could I then just make progress in the 3 minutes I have available? I think we've already foreshadowed the debate about my sixth point, which is about the 14th of August versus some open-ended date. The Commission heard right up front, I said that that would be a judgment made by the Commission as to how it fixes it or doesn't fix it, having regard to the medical evidence in front of you. I'm not going to deal with that further. May I just say then on this issue of the the independent assessment, I think we've debated that extensively already. It turns on the characterization of whether it's voluntary or not voluntary, and it also turns on whether it's facilitated or not facilitated. And there's consensus between Mr. Carrim's treating doctor. If you read paragraphs 90 to 94 of the paginated pleadings, I don't need you to go there, I'll just give you a note. Paragraphs 90 to 94 at record pages 53 to 54, and this is also the sequence that the Commission's own expert agrees with. And if you look at paragraphs 18 to 19 of Annexure MT1, I think I've given you that already, you'll see that there's a synergy between that. So if any direction is made regarding Mr. Carrim and any voluntary medical examination, we would ask that the Chair takes into consideration the involvement of Mr. Carrim's treating clinician. We also know that there's a threat of a referral for prosecution if Mr. Carrim does not appear again, whether advised or not advised, to not appear based on his medical condition. All I'll say in that regard is if the Commission feels, and when I say Commission, I mean the evidence leaders through the Secretary, or is it through the Chairperson through the Secretary, feels that an offence has been committed and that a referral for prosecution must be made, then the evidence leaders must do what they deem appropriate, and Mr. Carrim will also do what he deems appropriate, including leading evidence, whether at a pre-prosecution decision stage in front of the NDPP or at a post-prosecution decision stage in court, that he was medically and legally advised throughout, and that any prosecution will fail because there's an absence of willfulness, and that will be demonstrated on the evidence. But I don't think you have to worry about that so much. That's out of your hands once any such recommendation would be made. I'd also just point out, and I'm trying to sweep now in the 15 seconds I have left, I just want to point out 3 interrelated propositions, if I may. The first one is that you will know on the last occasion, not when my learned friend Ms. Hassam was here, but when my learned friend Mr. Chaskelson, who's not in his usual place today, was here, there was some debate between whether or not, if Mr. Carrim doesn't appear in front of the Commission again, and Chair, this takes us back to our recollections may vary, because what I seem to remember is after you and I had that discussion about voluntary versus compelled, the discussion then moved to what are the inferences that can be drawn in the ordinary course about the so-called unanswered questions that Mr. Carrim would not have answered by the end of this process if he never comes to the Commission again. I see the Chair is nodding, so at least I'm remembering that correctly, I think. But the point that I would make is at that time, and in its letter of the 24th of June, the Commission's evidence leaders were emphatic that if Mr. Carrim doesn't come again, they're not going to entertain this business about a postponement or no postponement. They were going to ask the Commission to make conclusions, or even on an inferential basis, on the basis of those unanswered pieces of evidence, and if necessary, to make a recommendation. And all I would point out is that the sudden change in now seeking to compel Mr. Carrim here seems to stand at odds with that, and the Commission must take whatever decision it wants to take regarding how it deals with Mr. Carrim in circumstances where it has direct evidence in front of it explaining his non-attendance, as it were. The last 2 points I'll make, and it is really the last 2 points, I'm 1 minute over time, is that there are many new allegations that are introduced in the answering affidavit of the Commission. And you know that on the papers, and particularly in the correspondence, I'm going to use my favorite A word again, there's a statement made about trial ambush, in the sense that not the entire case is sought to be answered is made clearly for Mr. Carrim and his legal team and the deponents on his behalf to answer, and then they are ambushed after the fact to say that you've failed to answer this, or that you're being deliberately misleading or inaccurate, whereas there are innocent explanations for these things. And if the Commission just showed its hand earlier, then it could have been dealt with earlier, and we wouldn't need to go 17 rounds in exchanging affidavits and supplementary affidavits, because we'd know the case to meet. Chair, you'd remember you said to Mr. Chaskelson the last time, put it on a piece of paper, those questions you want answered, that was supplemented by Commissioner Khumalo. It's the same complaint, with all due respect, that we shouldn't be drip-fed information. We should know what the Commission has in mind, so we can be helpful to the Commission in answering whatever we can, whenever we can. And lastly, may I just say that on the issue of the relief, the terms of the relief are obviously to be finalized, but on the underlying request for the postponement to a specified date or to some other date is ultimately unopposed. And that's Mr. Carrim's submissions in 1 hour and a bit. Thank you, Chair. 1 hour and 3 minutes.
Oh, thank you very much, Mr. Premier. Let me just